questions throughout the seminar. And the webinar audience, feel free to put your questions into the Q&A and they'll be passed on, and we'll ask those during the sessions also. It's now my pleasure to introduce our panellists. Bianca Mazzarella in the middle, who is a special counsel at the firm, an employment lawyer and a member of our litigation team. She specialises in a whole gamut of employment law and extensive experience on complex employment matters, including contractual drafting, workplace policies, workplace investigations, discrimination, harassment and bullying claims. Christine Roberts is the HR and Office Manager here at Aitken Partners, closest to me. She's been with Aitken in the legal industry for over 30 years and has extensive experience in HR and recruitment processes, and certainly someone we rely very heavily on, and is in a prime position to assess the constantly changing landscape. Stephen, fashionably late.
Sorry.
He's a special counsel at the firm with over 45 years experience in law, including general commercial law and employment law. He's also a qualified mediator with extensive experience and expertise in the resolution of a broad range of commercial and workplace disputes. Please join me in giving a warm welcome to our guests. We'll jump straight into the question and answer. Bianca, if I could turn to you first. Obviously the right to disconnect has been very topical recently. Could you give the audience a little bit of a précis about what that involves so we're all on the same page?
Yes, thank you, Alex. I'm sure that you've all seen a lot about this right to disconnect in the media, and so I'll start with what it means and how it's come about. So basically there has been the closing the loopholes legislation and the second tranche that's recently come into effect, and that has resulted in changes to the Fair Work Act, which give employees additional rights. And effectively what the legislation says is that an employee has the right to refuse to not respond to, not review contact from their employer or from a third party related to the employer outside of working hours, except where that contact would be reasonable. So that's promoted a lot of discussion, which I'm sure we'll get into today. But I think one of the most important parts of this legislation is protecting award-covered employees and lower-level employees. I myself had people contact me and text me and say, "Oh, that's great, Bianca, you don't have to respond to those 8 o'clock emails." I'm guilty of sort of being on my phone a lot. And unfortunately, it doesn't usually apply to that sort of senior level employee, and we'll discuss a little bit more about that today.
So you've touched a little bit there on the word reasonable. So what does that mean in the context of if that contact is reasonable, then there is an obligation to respond to it?
Yeah, so it looks at a variety of factors. So you're looking at the type of contact that's made, you're looking at the seniority of that employee, whether or not they receive remuneration that covers them for those contact outside of hours. Touching on that point, often how I draft a lot of my executive level contracts is saying, you're a senior level employee and you're expected to be available outside of hours where necessary, and we have remunerated you for that. So that's going back to what I touched on briefly before in relation to myself, and lots of people will fall into that category too, and employers making sure they have policies around that as well. Another factor that takes part is whether or not that employee has parental leave responsibilities or carers responsibilities. I think we'll find that the Fair Work Commission will be quite unforgiving if you're contacting somebody that an employer specifically knows leaves at 4 to pick up the kids, and then, for example, if an employer contacted them at 6 for something urgent, I think we would find that that contact would not be reasonable, and that an employee would be able to rely on this new workplace right and that right to disconnect, particularly where they're an award covered employee. So they're sort of some of the factors that will come into play.
Thanks, Bianca. And I mean, when this sort of new workplace right comes into effect, I know most employers think, okay, well, how do I have this enshrined in my business. Is this something that employers should be looking at having a policy in place for?
Absolutely. I think lots of employers will get caught out if they don't, particularly what I'm talking about in terms of the contract and having those provisions to cover off that, even if they're not a senior employee, but if their remuneration does take into account contact after hours, that should be specifically stated in the contract. And they should also have policies. It's not, mandate that companies have policies, but of course, if there is a claim and claims that will arise that we'll speak about further are like, stop the right to disconnect, stop the contact that employees and employers can make in relation to what's reasonable and what's unreasonable, and also general protections applications. And if an employer cannot rely on terms of a contract that have been specifically drafted or specific workplace policies that set out when contact is reasonable and unreasonable and what they will take into account, I think they'll find themselves at a bit of a loss in terms of defending those applications.
Christine, from an employer point of view, what should happen when an employee comes in and complains about being contacted out of hours?
Sure. We would deal with a complaint like any complaint. We would obviously need to understand its intentions and the urgency of why that direction or the employee was approached to see if it was reasonable. And then again, as a complaint, we would investigate and speak to both parties to make sure that there's a reasonable understanding for future contact, if it was reasonable or unreasonable.
And I suppose this is for Bianca or Stephen. In the unfortunate event of a dispute, is there a process whereby these disputes or applications are dealt with under these new laws?
Yeah, the Act says that the Fair Work Commission can help with resolution of issues, and it can arbitrate in the event that there is an issue that can't be resolved by agreement. So either party can approach to the Fair Work Commission. But it's also worth noting that if the employer does something against the employee as a result of the employees exercising their right to do this, then that can be considered an adverse action and can result in a general protections claim. So it's very important for employees to know that remedy is available to employees.
And they can also make an application like an order to stop bullying application. So if there is repeated conduct where they feel like the employer is going to repeatedly make conduct that's unreasonable, so not a one-off but repeated conduct, sort of like bullying, you can make an order to stop. You can try to get an order from the Commission to stop that unreasonable contact to the employee, or vice versa. The employer could go to the Commission to try to get an order to stop the employee from refusing unreasonable contact.
And so what are the main factors or points that the right focuses on? Again, Bianca or Stephen, if you can.
So I suppose what we're trying to look at is stopping that contact to employees where it's outside of hours, where they've got other responsibilities, where they're not at that high level executive, where they're remunerated. And it's also protecting employees from adverse action being taken against them, i.e. you contacted 6 p.m. on a Friday, you don't respond, Monday you've got a warning, Monday you're demoted, Monday you're fired. So it's giving employees further rights under the Fair Work Act.
Shifting focus a little bit, Christine, can you address some of the prominent recruitment trends that you're observing at the moment? Perhaps over the last year and what you're seeing moving forward?
Certainly COVID's made some changes to the outlook with recruitment. One is the flexible work arrangement. People are really keen to have some flexibility in their role, be that to care for children or carers, or sometimes they've decided to take a country change in the COVID period, so there's a travel issue. So we're finding that that's certainly something that is one of the drivers for candidates today, to have that flexible. Sometimes that could be starting at 7 and finishing at 3. It doesn't always have to be a day working from home. But it also really has to make sure that it suits the business needs as well. It's not just all one way. So we have to find a balance with this that supports both the business and the candidate. that's certainly one. One recent question I'm asked, more so this year than ever before, is what's the layout of your office floor plan? Are you hot desking, are you open plan, or do you have private offices? And funnily enough, people want the private office again to do their job, particularly if there's a sensitive area of law. They want to have that conversation with the client, and they don't necessarily want chitter-chatter, laughter, and all that coming from the floor of the office. So that's an interesting question, and seems to be a bit of a driver for lawyer candidates today. What other things are there? The most important thing is to make sure that you've got an environment that allows your teams to constantly talk and mix and socialise. Working from home has its issues where junior staff are keen to come in, which is what we're finding, but potentially the more senior staff are keen to maybe work from home a little bit more. So we're losing that disconnect of that mentor for the junior staff. So whilst we're encouraging our junior staff to come in and learn and upskill, we're also encouraging our more senior staff, Steve for one example, to be here and help mentor our junior staff as well.
You've touched a little bit on, I suppose, what candidates are looking for in flexible working. Can you give us some more examples on that? Obviously specific to the legal services industry, but what are the critical things that you're seeing that they're asking for of potential employers?
Sure. Firstly, to have the flexibility that if they've got, particularly I suppose children are the most common issue that people may have, young family, to have the flexibility where they can start early, finish early, like I said before. Also to be able to have the flexibility to work from home and provide that care for them, but also in turn that we are supporting that and having the tools for them to do that. Equipment's really important in order to do that, so we have to make sure our staff, if they do work from home, have the right tools in a safe environment to do that. And really just have that flexibility, but also make sure that we don't forget who they are. They're working from home, we keep connected with them.
And remuneration is obviously a critical part of any employee's decision. How are you seeing those salary bands shift in the professional services sector at the moment? And what should employers do when they're trying to set competitive salaries with their competitors?
As part of the survey in the legal industry, which I'm part of, we've, the last sort of, I suppose, this financial year, we're seeing that the salaries are stabilising. That there is candidate short market still, but we went through a bit of a sort of an uncertain time through the COVID period trying to attract staff. Salaries did go up, they escalated, now we're finding that they're stabilising. So I can't talk on behalf of other industries, only the legal industry. But we have to be mindful and aware that people may have different, it's not just about the dollar. It could be that they prefer to have 5 weeks leave as opposed to 4 weeks leave. There could be all different factors that come into that as well.
And Stephen, what legal considerations come into it? We've spoken a lot about that remote or flexible working. What legal considerations should an employer be aware of in that circumstance?
Well, there are two sorts of agreements. There are the individual flexibility agreements that employers can negotiate with employees individually, and there are terms around those sort of agreements. Where there's provision in an award for that sort of thing or an enterprise agreement, then the parties can make an agreement in relation to things like hours, overtime, penalty rates, allowances and the like. And those sort of agreements, these are agreements that are not part of the employment contract. They're separate to the employment contract. They're ones where negotiated separately, documented separately, and can be, they're not to be standard, and they can last as long as the parties agree that they will last. Okay, so they're the enterprise flexibility, the individual flexibility agreements. There are also the flexible working arrangements requirements, which enables employees who have been employed for 12 months to request flexible working arrangements. They have to be certain types of employees. They have to be a parent with responsibility for school-aged children, or less, a carer under the Carer Recognition Act, somebody over 55, somebody who's pregnant, or somebody experiencing domestic violence or supporting somebody close who is experiencing domestic violence. And one of the options for these flexible workplace arrangements is the ability to work at home to some extent, or fully, I guess. Now, if an employee wants to make that sort of request, they have to make it in writing, and the employer has 21 days in which to respond, and must respond with reasons. If employers are allowed to respond, if they give reasonable grounds for refusal, they are allowed to refuse if they give reasonable grounds for the refusal. For example, it might be too costly for the employer. It may be too difficult to arrange other employees to deal with the sort of things that need to be dealt with by the existing employee. Or the request might result in significant loss in efficiency or productivity, or have a significant impact on customer service. In those circumstances, the employer can say, no, that doesn't work and I'm rejecting your request. Any response has to have the reasons for the response and detail other changes the employer might be prepared to make to accommodate the request. The employer must also advise the employee in responding that they have the option of going to the Fair Work Commission for assistance to deal with the issue. So that's really how those individual flexibility agreements and flexible working arrangements work.
Thank you, Stephen. And anyone can jump in and answer this question. We've obviously read a lot about gender equality over the past several years, but particularly over the last 12 months. How can companies and employers in particular ensure that they're meeting those gender equality goals and working towards all those things that we're reading about in the media?
I think this flows on to, unconscious bias, and instead of looking at somebody and thinking, oh, well, she's a young female, she's just got married, I don't know if I'm going to employ her because she might have a baby soon and leave us high and dry. I think it's important not to, I think it's natural too, by the way, that people think those things, but rather there should be an objective criteria where you're assessing two candidates, I'm using the male and female example, where you're asking certain questions about that candidate and their skills. And so those unconscious biases don't creep in, and so they can be assessed more effectively in terms of gender equality. I had a really good experience. I was employed by quite a large law firm for a number of years. I was that young female that was newly married, and I got offered a job, and then I found out I was pregnant and said, I know I'm an employment lawyer, but I'm not going to do anything about this if you decide not to hire me. And I let them know that, and they had a really good strategy, which I really respected, that was, well, no, we see you being here for a long time, and I did go on to work there for a while. So I think that companies need to think of that too, and really it also comes down to them being aware of that unconscious bias, and we're really wanting to promote people irrespective of gender.
Great answer, thanks Bianca. Anything Christine or Stephen would like to add to that?
I think it's important also in when you are, let's think about recruiting a role, that we are considering that the candidate is there with the right skills equally, that they are paid in the same salary bands equally. So those things should be considered regardless of their gender. We are looking at people for who they are, not for their gender. And it's critical that we're getting the right skills for the right job. And that's really should be your driver.
And people talk as well, so it's also giving that positive image for your company, for your firm, to say we're supportive, and we take these measures to make sure that we don't fall into that, because lots of companies don't want to do that, but they do it unconsciously or for whatever reason.
And so how can then employers create policies or systems internally that support that inclusivity and obviously comply with the employment laws first and foremost, but promote that sort of environment?
Yeah, so they should have adequate policies about it. You know, it might be as simple as internally, you know, do we have X amount of females and X amount of males, as well as in management positions as well. I think there has to be a really conscious decision by HR and management to make sure that they have those adequate policies and supporting parental leave and so on. It's, you know, I have many conversations with women and men about, you know, what the parental leave policy is, and that really adds value and longevity for employees staying within businesses.
And the policies are important because they set the standard for the employer. They're the published standards the employer adopts, and it's helpful to have those policies for that sort of thing and the other policies, so that everybody understands what the standards the employer requires are.
Thanks, Stephen. And certainly when I was coming up through the ranks as a lawyer, while salary might have been important, it was a sense of wanting to improve that was the biggest decision maker for me as an employee. So what can companies, obviously talking about law firms, but even more broadly, what can they do to invest in upskilling their staff, and how do you sort of approach that from an employer point of view?
I think I touched on it a bit earlier, that there's nothing more invaluable than having a experienced and senior member of your firm mentor and train the junior lawyers coming through. It's something that I often ask the question, when you were young, who trained you? Now it's your turn to pay back and move forward. So I think that we don't necessarily have enough value in our senior experienced staff within an organisation. But that's one. It's about client engagement, fast tracking work, how to work effectively, time management, all those skills that you just learn over time that can be transferred back to the junior lawyers. But with lawyers, they have to do CPD training, so we're always looking at different, you know, there's obviously the legal training they need, but it's also ethics and skills, and how to effectively do management and business skills as well. So it's just keeping abreast of all of those to support them. And don't forget about your support staff as well. They are really important to any organisation, and they should also be equally supported.
I might pause for a moment and see if anyone from the audience has any questions they'd like to address to the panel broadly, or anyone specifically. Yes?
Going back to the word reasonable, is that fully defined in the legislation, or does it depend on case law? Because reasonable straight away indicates there's some uncertainty.
Yeah. It's not defined, but the parameters that we've been given is, you know, what I stated before in terms of, you know, parental leave responsibilities, the mode of the contact, whether or not it's urgent. And it'll be interesting to see how it plays out and how it's addressed. Yeah, and it will certainly be on a case-by-case basis. If you look up Fair Work Commission, right to disconnect, they give examples. Like one of the examples that I read the other day was, you know, an employee finishes work at 4 p.m. and everybody knows she goes and picks up her kids from work. You know, would it be reasonable for her employer to contact her at 6 and then expect that she would respond? The answer is probably not. So that would be deemed unreasonable. But in another example, if you've got an employee that has no care responsibilities, usually finishes at 5, there's a task for a client, it's urgent, it has to be done by 10 a.m. tomorrow, she works the next day, she's contacted at 6, would it be reasonable that she responds? Oh, and she's you know, remunerated accordingly. Yes, that would be reasonable. So I think you can sort of apply a little bit of logic to it in that way, but I think the main sort of red signs are looking out for parental leave responsibilities. Are they remunerated for that additional work? And is the request urgent? You know, that there are circumstances where employers, for whatever reason, you know, stress employees out by contacting them over and over unnecessarily after hours, and it's trying to protect those people. So I think a lot of logic should be applied to this, and I think it will be by the Commission.
But it indicates a loophole straight away, and it's open to interpretation. Each side will have a different interpretation.
Absolutely.
And part of the problem
Absolutely.
lies in that grey area between the examples that Bianca gave, which I suppose just highlights how important it is to keep your eye on those factors that are defined and you can rely on, but I agree with Andy that there is always going to be disagreement, particularly where it isn't quite as clear cut as either of those examples.
And if you're an employer, the idea would be to, you've got to appear to be reasonable. The main burden will be on you rather than the employee, the way things are, of course. You'll want to indicate that you've done everything reasonable that you can do to accommodate the employee.
And the way employers can protect themselves is by having the right provisions in their contracts for the employee, and also having those workplace policies that can, define what's reasonable and what an employee can expect, so that both parties know what's expected of the relationship.
Yes.
I'm not sure whether you can answer this because it's outside the scope of what you're talking about, but there's a huge sector of the student market out there that are working for cash money, and in that instance, are there any rights or liabilities on either party when that is in fact the case? I mean, can you answer that question?
So the question, just for the benefit of those online, is there's a big student market out there where they're accepting work for cash payments, and what are the sort of rights and liabilities on the parties in that sort of arrangement?
My view would be that, notwithstanding they're working for cash or what they like to think are outside the terms of an award
Yes.
or an enterprise agreement, that if push came to shove, they'd probably be considered to be employees with entitlements.
Okay.
So if they're doing clerical duties, for example, and that's an unusual example, but a commission would say, well, you're doing clerical duties, you're entitled to the benefits and the coverage of the clerk's award. Obviously, these people do these sort of things by agreement, but the difficulty for any employer is that it may cease to be an agreement at some stage, and the employee may turn around and say, no, I should have been covered by an award, I should have been paid a higher wage, I should have had other benefits, and they might find themselves looking at a claim that they have been guilty of wage theft.
So liability really lies with the employer.
It does.
Okay, that's great.
And the penalties are quite high. You're
Yes.
looking at not only underpayments under an award, but the penalties are per breach, which can really add up.
Okay.
Any other question? Yes.
If we're using outsource, as a firm, apart from fairly paying and whatnot, what sort of thing that we need to look out for as an employer?
So using an outsourced sort of arrangements, what does an employer need to be aware of in that context? So contractors, I think.
Yeah, so
As a
you've...
firm, we use outsource in the
Yeah.
Philippines or whatever.
Okay, I'm
Offshore.
Philippines.
Yeah.
Mm. You're probably looking at, so you're talking about a company that's based in the Philippines engaging somebody who's working in the Philippines, is that right?
Yeah.
I think that that's a really good question, but I think the answer is that they would probably not be covered by employment laws in Australia if they're based in the Philippines. And I'd be very careful. I'd need to know more about the circumstances, but there is a prospect that they wouldn't be covered by Australian laws.
And would that change if it was an Australian-based company that then used an
People-
offshoring
Yeah,
arrangement?
well,
Likely, yes.
yeah, you'd have to have that'd be closer to coverage by Australian laws, but you'd really need to know more about the circumstances.
So it sounds like the answer is that's very complicated and sexy.
Yeah. I think there are. It manifests itself in most recently in the offshore oil rigs, where companies were engaging international labour to work on the rigs, but the rigs were governed by Australian laws, and I think that the workers were found in those circumstances to be covered by Australian laws. But again, it will depend upon the circumstances.
And it's obviously a prevalent issue, I think, of the partners of law firm and accounting firm people that I speak to at the moment. I think it's 70% or something would be using offshoring in some way, shape or form. So
And that would probably be using a company in India or the Philippines or something like that, which engages its own labour, which I think is as far away as you can get from being responsible for those employees.
It's one to be careful on, and I think the best thing to do is to get advice that the particular circumstances can be analysed. I had one not so long ago where the company originally employed this person here, and they were over in the Philippines, and then so they were here, employed by a company here, paid in accordance with award rates. Person goes to the Philippines, they want to work over there, and they negotiate a much lower rate. And after my analysis, my view was that they would be covered by Australian laws in that circumstance. And you know, they'll all vary, but it's one to be careful on.
I have a question about the recruitment issue, and I don't know whether the law apply for this sort of issue. I just give you my personal example. I think about more than 2 years ago, the Queensland QCAA, that's the Queensland Cooperative Administration Agent or whatever, they publish a position for the Queensland Art Gallery. That is about the curatorial manager for the art of Asian and the Pacific, and with the language of Asian and Pacific is desirable or whatever. I applied, but of course the Queensland Art Gallery say not successful or whatever. But I asked her for feedback, but feedback was taken really 1 month, and I have to complain to QCAA. Then I got a feedback. The feedback simply stated, this is regarding, they acknowledge my knowledge and skill, whatever. Say this, however, this is about broader geography of Southeast Asia and the Pacific. That means different from the original published title. So I said, this is discretion. I need an explanation. I asked QCAA. I don't know, the Queensland system may be not unlike in Melbourne or whatever. And the lady over there said, this is a bureaucratic issue, because we don't know what the gallery want, particularly or whatever. I said, that's not fair to us. You publish, your publication got a 4.5 page, very long, very detailed, blah, 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 blah. But you even cannot identify what exactly you want. This is, I think this is discrimination. He said, no. We will show you this is how the selection will be processed. Give you some insight. Okay.
If I can step in there, I think that's the sort of thing that could be taken to the Discrimination Commission in Queensland, and
exactly.
that would be where your remedy would lie.
I took this matter to Queensland Discrimination.
And have you had a result from them yet?
Had a result in 7 months.
Right.
I raised this once, 7 months I got nothing. And the 7 months they said it's not discrimination, blah, blah, blah. I don't understand.
It's very
put a
difficult.
lot of direct, indirect, I don't understand. But then I went to QCAA, Queensland, like a VCAT, like a QCAT. QCAT, without the commission recommendation, we cannot deal with that.
It sounds like a very complicated matter. I mean, I don't think we've got the time
It's
to
very
do
funny.
that.
I just want to know, go back to the fundamental issue. As you said, you can raise this with discrimination. I believe this is discrimination, very clear. But still, in the end, now I'm a racist one to the Court of Appeal in Queensland.
think I might just jump in there. I think this is a question we might defer.
Yeah.
Feel free to come up to someone else.
It's okay.
Because there
Yeah.
is some complexity to what you're
Yeah,
asking.
because I very interested in recruitment like law, so I just want to know that.
Okay.
I met 3 times. First the art gallery of New South Wales in Sydney. I had an interview. Adelaide
Sorry, sir.
Gallery. I had an interview. In the end,
Yeah.
so I feel like this time I have to find what's going on.
Yep.
Thanks. Sarah, can I jump over to you?
Just a question, probably for Christine. You talked about the difference in gender with recruitment. Could you give us a little bit of insight or conversation maybe from the panel about the gender pay gap and what you're seeing in the industry and if that's changed over the last few years?
Sure. I'm proud to say that there isn't a big gender gap in the legal industry. Certainly there would have been many years ago, but for the survey trends that we're one involved in and that we see, it doesn't even touch on the gender. It's purely based on skill, experience, and sometimes the area of law. So I'm sure it's in potentially other industries. I can't speak for those, but I believe there's a lot of voice now that's making sure that these things are starting to balance out, I'm sure.
Well, there are a lot more females in the law now than there are in the
Well,
law.
I would like to share some stats that I just did read recently, that 55% of lawyers in Australia are female, and the new upcoming lawyers through uni, 86% are females. So that's going to make it very hard for law firms to really, or challenging really, to make sure that you are considering the gender equality when the pool is so large.
Do you know what those stats are at partnership or senior
No.
management level?
No, I don't. But that would be good to look at.
I think there's probably still a little bit of
Yeah,
discrepancy between
yeah,
what
I think
we're
that's
seeing
still
at
the same.
senior
Still
level.
the same then.
That just
Yeah.
shows there's more
Yeah.
work to be done,
Mhm.
notwithstanding that. Bianca, Steve, anything else on that?
No.
Yes, Susan.
Question on the right to disconnect. If I'm a senior level, not covered by the award, so it doesn't apply to me, and I'm working at night, because that's part of my flexible
Yeah.
thing where that's where I like to get work done. If I want to send an email or a couple of emails to people who are covered by the award and the right to disconnect applies to, should I just not send them at all? Or should I preface it by saying I don't expect a response to this right away? Can I still email people outside?
I was thinking that exact same thing, because often I send things to juniors late at night, but I don't expect a response. It just suits me to get it off my plate. And I'm so glad you brought that up. I think the right thing to do is that you're not expecting a response, and provided you're not punishing that person or taking any kind of adverse action because you're not getting a response, then I don't see how there could be any great issue. But I think the right thing to do, and I have to do this myself, is to just say, just letting you know, I think you know, I just send it to get it off my plate. I know you're not working, and I certainly don't expect a response. Yeah.
I think for those in the room who deal with government agencies at the moment, like the ATO or similar, you actually see it on their email signature. I have an arrangement where I work outside of normal hours, I don't expect a response, and those sorts of things. So you do see them explicitly say that in email signatures.
And the legislation talks about an employee may refuse to monitor, read or respond to contact. An employee may refuse to monitor, read or respond to contact. So it's more about their right not to, rather than any prohibition on your sending it, I think.
And if you're not demanding a response, then
I suppose the only difficulty is where you have employees, and we certainly see that in law, people tend to be driven, ambitious people that don't necessarily want to be responding, but as soon as they see that email, they feel obliged to jump in and respond.
Yeah,
So,
occupational hazard.
But could that be a delayed send on your email then?
Yeah, you could do that.
Instead of hitting send.
So it hits the mailbox at 8:30 the next day is another option. Or having that communication with the person that you typically could email. I might email you at night time. Don't even look at them. It's just, I'm going to work back late for my flexible arrangements. Don't need to respond. So you have that communication, and I think that's more powerful.
I've also heard about sort of hypotheticals where like a pool of junior lawyers
Yeah.
who might get emailed after hours, and it might be the people who respond at 10 o'clock at night who will get rewarded for that. So I think that's something that people, or HR has to be aware of,
Yeah.
that you shouldn't be rewarding people who are.
And that would be part of the adverse act, like say there was a claim, which I actually think would be really hard to prove, because, you know, how do you prove that that was the reason? But, you know, that somebody's discriminated against or doesn't receive a promotion, and that that's a form of adverse action, but yeah, hard to prove.
We've spoken a little bit about junior employees, I suppose. What about from a senior employee's perspective? If you know, an owner of a law firm, or indeed any company, says, I've got a senior employee who's refusing to respond to anything outside of hours, is there anything an employer can do to say, hang on a second, I actually need you to be doing this outside of hours for whatever reasons? How do you approach that?
Yeah, so you can, so if it's repeated conduct and you had an arrangement in place where there was a contract that says you're a senior employee and you get remunerated X to be, you know, responsive, and you may be contacted out of hours and they don't, then you can make an application to the Fair Work Commission to try to get an order to get them to respond when that contact is reasonable. And it goes the other way too. So yeah, an employee can also make an application to get an employer not to contact them, except if it's reasonable. So yeah, the Commission has the power to make an order.
And if there's a provision in the employment contract that requires the employee to be available to respond outside hours, then that'd be a breach of the employment contract and could be a disciplinary issue.
Any other questions from the audience? Yes.
What are the financial implications if there's a breach or something that's gone through Fair Work with a right to disconnect? What's the implications for a company?
There's no criminal, but there can be equitable ramifications. But I was reading something the other day that was like, you know, the purpose should not be for punishment for either side. So I think it'll go more like a bullying application. And the commentary that I read was around, let's see how this act plays out and what actually, you know, occurs. And I've read that they'll probably adjust that yeah, after they've had the benefit of seeing how this transpires in practice.
Bill, do we have a question?
Yeah, from online. Does the right to disconnect apply to contractors?
No, it does not. You have to be an employee. And now I'm not going to go on a tangent about sham contracting because it's one of my favourite topics, but if you just think about it practically, you know, if you've got somebody that you're expecting to be available, then that's got a flavour of an employee relationship. So it would make sense that if you have a contractor, that they're doing a job by job basis in their own time, they're like their own little business person. So the right to disconnect does not apply to contractors, and if you think it does, then you've probably got other problems because you're probably in sham contracting territory and you should get advice.
And the other thing about that is that the right not to respond applies to communications from contractors as well as from employers.
Yeah, any third party related to the employer.
Any other questions from the audience? If that's the case, I might bring everything to a conclusion. Thank you very much to our panellists, and that concludes our panel discussion this morning. Thanks everyone for attending, and have a great day. Thank you.